trumped-up charges, unraveling the unfairness of political prosecution. Manhattan District Attorney Alvin Bragg has wrongfully prosecuted a criminal justice reform advocate, an NYPD officer, and a former Republican president of the United States for seemingly political reasons, a Law Journal contributor writes. The eyebrow-raising legal theory behind Alvin Bragg's case against Trump. It's important to take a minute to digest what the prosecution had to prove beyond a reasonable doubt. Lawfare is the use of legal systems and institutions to damage or delegitimize an opponent or to deter an individual's usage of their legal rights. The term may refer to the use of legal systems and principles against an enemy, such as by damaging or delegitimizing them, wasting their time and money, e.g., strategic lawsuits against public participation, or winning a public relations victory. Alternatively, it may describe a tactic used by repressive regimes to label and discourage civil society or individuals from claiming their legal rights via national or international legal systems. This is especially common in situations when individuals and civil society use nonviolent methods to highlight or oppose discrimination, persecution, corruption, lack of democracy, limiting freedom of speech, violations of human rights, and violations of international humanitarian law. When Manhattan District Attorney Alvin Bragg first brought charges against Donald Trump in March 2023, the legal theory behind the indictment remained remarkably unclear. Bragg had charged Trump under New York penal law, paragraph 175.10, falsifying business records in the first degree. The falsification of business records alone is a misdemeanor under paragraph 175.05. But Bragg had boosted the charge to a felony by alleging that Trump fudged the records with the intent to commit another crime and aid and conceal the commission thereof. But what other crime? The indictment didn't say. Now, a year later, with the trial finally underway, Bragg's legal theory has come into focus, if you know where to look. The charges against Trump still have an oddly inchoate quality, thanks to Bragg's decision to charge paragraph 175.10, without also charging alongside it the offense that elevated the alleged business records violation to a felony. But in court filings, opening statements, and one particularly informative conversation with Justice Juan Merchan, the district attorney's office has made its thinking a great deal clearer. As the press corps straps in for what could be a long few weeks in New York Supreme Court, it's worth taking a closer look at the legal mechanics underlying the allegations that Bragg's office must now prove beyond a reasonable doubt. Understanding this emphasizes the importance of the underlying FECA violations to Bragg's case. The wrongdoing under federal campaign finance law supports 2 out of 3 remaining object offenses, seen in a certain light that makes it all the stranger that the U.S. Attorney's Office for the Southern District of New York itself never brought federal charges against Trump under FECA, a decision for which there has never been a public explanation. Summing it all up, let's return to our chart for a moment. Once we incorporate the unlawful means needed to reach the paragraph 17-152 object, offense, it looks like this, clear as mud. In all seriousness, what this deep dive has hopefully shown is that Bragg's legal theory is genuinely tangled, though the district attorney's office is doing its best to clarify matters. The next few weeks will show whether he's able to walk the jury through it.